Travelers versus Royal Oak.
No, sir, it's Langley versus Knowles.
Oh, I'm sorry. I looked at the bottom of the thing. That's case that's been done. Langley versus Knowles. You're right.
I mean, I'm normally prepared, but I wasn't that prepared. I would like to reserve 5 minutes for rebuttal.
Okay.
May it please the Court, my name is Jamie Bellotti-Moses from the Orlando law firm of Fisher Rushmore. I am here today representing the appellant, Mr. Langley. We are seeking a reversal of the summary judgment entered by the trial court and the subsequent attorney fee award pursuant to the summary judgment that was entered. I apologize that you now have your second lien case of the day. Would the Court need or like a brief recitation of the facts, or would you like me to go straight into argument?
You okay on argument? I think we're all familiar with the facts.
It is our contention that the trial court improperly entered summary judgment in this case. As procedurally, this went before Magistrate Judge Glatt. He made a recommendation to the trial court that on the lien foreclosure claim, summary judgment be granted as a result of the substantial performance doctrine. He recommended, however, that the summary judgment be denied with respect to the 3 remaining claims in the case, the breach of contract claim of my client and the 2 counterclaims of the Knowles. Objections were presented to the court. The trial court overruled those objections and entered summary judgment in accordance with Judge Glatt's recommendation. It's our contention that that summary judgment was improper because the substantial performance doctrine should not have even been applied to the facts and circumstances of this case, for one reason. Number 2, the substantial performance doctrine is traditionally relies upon substantial performance, which is a question of fact for the trier of fact, and this court held so in an opinion in which Judge Orfinger was involved. And there were issues as to whether, even if that theory applied to this type of circumstance, there was an excuse or waiver of performance. So it is our contention that summary judgment was just clearly inappropriate in this context.
All right. So I understand. Because of factual disputes or because of misapplication of the law?
Well, actually both. Actually both. It is our contention that this isn't the type of case that the substantial performance doctrine should have even been considered. However, if the court disagrees with me and thinks it should apply, there were questions of fact involving its application. The reason why it's our position that it doesn't apply is the substantial performance doctrine actually, I believe, and I wasn't around when these cases were decided many years ago, but was a way to protect.
Did you say that Judge Orfinger actually sat on one of those cases?
No, not that case.
Oh, okay.
But those cases, in my interpretation of reading these cases from the 30s, 40s, and 50s, were that this was a doctrine to protect contractors who wanted to place the lien but had not fully completed the job. There was some slight problem, and they wanted to sue for the entire contract price and the contract amount. And the court said, look, if you have substantially performed, you're entitled to recover the full contract price, but we're going to make some deductions for what it might cost to fix what you haven't done or to fix a little error. In this case, it's been presented as a complete defense to the claim. Contract price is $11,000. You liened us for $2,900. That's 25% of the contract price. Clearly not substantial performance, and therefore you lose as a matter of law. And it is our position that the substantial performance doctrine is if we had sued for the $11,235, which was the contract price, then the argument could be raised, you're not entitled to the contract price because you haven't substantially performed. In this case, we only placed the lien not even for the amount we originally thought we were owed, which was $2,900 for the material and labor provided. We placed a lien for the $2,900 minus the amount that the Knowles paid Mr. Langley, that they felt that's all they owed. The lien amount was only the remaining $1,800. And there's been a suggestion in the answer brief that we sued for breach of contract seeking the $11,235. If you look back at the complaint in the case, it's clear that this lawsuit and the lien was only about what we thought we rightfully provided up until the day we were terminated, the materials and the labor, and that's it. Now it's been used, and the reason why the substantial performance doctrine should not apply is if that was the law of this state, then no contractor could ever assert a lien on a project, ever, unless they complete the project. And we all know that there was plenty of cases cited in both briefs where, you know, the parties stop working with each other early on, or someone fails to file or pay a progress payment. You can assert a lien at that time. You don't have to wait until the contract is completed and then sue for the entire contract price only. That would not
let me ask you this. Let's assume that we agree with you that just you have a contractor that goes out, does 25% of the work. The owner says, look, I don't want you here anymore. And the contractor can file a lien even though he's only done 25% of the work. But the Pitts case, which you all both talk about a lot in your briefs, you know, says there's no substantial performance. And they list three elements or three possibilities. One is just not substantially performed. Two is where he's failed to perform a material and considerable part of the work required on the contract. But three is or where he has willfully or intentionally departed from or failed to carry out the terms of the contract. Now that's the issue that interests me the most on this one, is when your client said, I'm not going to redo the footers. Because that qualifies as willfully or intentionally departing from the terms of the contract and refusing to carry out the terms of the contract.
Number one, I would submit that's an issue for the trier fact, because that is disputed in here. Mr. Langley's contention was that he was trying to negotiate with the Knowles a way to fix this, and then was advised, we've hired another contractor, we've ripped out your work, send us a final invoice. That right there, to me, is a question of fact, that even if you are concerned about that third prong, that's something that should be resolved by the trier of fact and not by the court on summary judgment.
Or did your client testify that he thought it was ridiculous to do the footer? Did he tell him that I'm not going to replace the footer? I'm not going to tear it out?
I apologize that I don't know that was his exact language.
I mean, he wanted to do a fix. Mm-hmm. And the homeowner wanted him to tear out some of the work he had done and do it as an initial plan. So my question is, did your client, in his deposition, indicate that he had told the owner that he was unwilling to redo the work, that he wanted to use a fix instead?
I thought his testimony was, and I am sure Ms. Atkins will correct me, and on the break I will look at the deposition. I thought his testimony was they were at a stage where they were still trying to work it out, and then he was suddenly told, no, you're done. Because he does state in his affidavit, initially the Knowles were receptive to what I was proposing. Okay? And then all of a sudden he hears, you're done, pull out your work, leave some of the materials that I'm paying for, leave it on the job site, but you're done. And I would think that that's a disputed issue of fact, because Mr. Langley's interpretation of his conclusion of the job and when he was done with it is obviously going to be different than the Knowles.
Let me ask one other thing. On the attorney's fees, you indicated the trial judge granted the attorney's fees after the summary judgment. Is that before or after the other accounts have been resolved? They
have not been resolved. We moved to stay, saying, look, it's up on appeal. You all just heard a whole bunch of argument about the net judgment rule. We haven't even gotten there. But the court said, no, we're going to consider it. The argument was, we're prevailing party, we get them automatically. There were still 3 counts outstanding. Well, they have not been resolved.
Theoretically, can you lose on the main issue here and win on the attorney's fee because we don't know what would happen on the other counts?
Theoretically, yes. And that's why this is a significant issue, because we've not only lost on the lien claim, but we've now been assessed $21,000 in fees, and the case is not over. And we did properly request a stay, and it was disregarded by the court.
Ms. Moses, let me get back to something you started your argument with. Did I hear you correctly? Did you say that in this instance the trial judge applied the substantial performance test as an affirmative defense?
I felt it was presented as a defense to the lien foreclosure claim.
That he had not substantially performed?
Yes. Where I feel in its origination that doctrine was created to protect contractors. If you look at the language, it talks about, so this is from the Ocean Ridge case, Substantial performance is that performance of a contract which, while not full performance, is so nearly equivalent to what was bargained for that it would be unreasonable to deny the promisee, who's the contractor.
I guess I understand what substantial performance is. I guess my question is, where do I go to look to determine whether the trial judge used that as an offensive weapon for the homeowner?
Because that's how it was presented in the motion for summary judgment. They didn't substantially perform, they don't get it. I mean, their motion for summary judgment reads very much like their brief, which is there's no substantial performance. This claim is barred as a matter of law, which is raising it as an affirmative defense, in my opinion. And since the court...
Was it in fact raised as an affirmative defense?
I'll have to look at the answer. I think it was. But since the court didn't rule on the other three, this wasn't a global determination as to the two breach of contract claims, the fraudulent lien claim, and the lien foreclosure claim. It wasn't a determination by Magistrate Glatt, look, I have a problem with this because of the substantial performance doctrine. Summary judgment was denied on the remaining three claims and granted only on the lien foreclosure because he said, I find that the substantial performance doctrine applies and this contract was not substantially performed, therefore they lose.
Well, no matter how you phrase it, I think the question is the owner entitled to have the construction constructed according to the blueprint, according to the plans? And if there's a deviation from the plans, does he have a right to say, hey, this is not what I wanted. I wanted it done according to the plans?
Yes, Your Honor. And that's what this case would have been about if we could have gotten that far. There could have been arguments raised as to why the lien was not properly asserted. And again, we weren't trying to get the whole contract price. We just wanted to be compensated for our materials and labor. We sued for breach of contract. They sued back for breach of contract and then a fraudulent lien over this interest issue, which is not relevant for today's purposes, but they've filed affirmative claims as well. But we don't even get there. We don't know. There's no testimony as to what it would have cost to fix that one problem. We don't know, and I'm now truly speaking hypothetically, but we don't know if they brought out a new contractor. He used all of our materials that were left on the property and fixed the issue still within the $2,900 that we were asserting the lien on. We don't know because just this blanket statement, substantial performance wasn't done, so boom, you don't get to go forward. It was just a premature ruling. That may ultimately be the decision.
Was the court's use of the term substantial performance perhaps a misapplication of the term? I mean, what he was getting at, of course, is that your client had not, admittedly, had not constructed the quarters in accordance with the specifications. And was he simply using that as a shorthand, he or she using that as a shorthand to indicate that there had been a failure of your client to perform that part of the contract?
You know, I can't speak for Judge Glatt, but the order capitalizes substantial performance, doctrine applies. I mean, it suggests to me, and what was repeatedly argued is this is 26% of the contract, 26% of the contract, not substantial performance. I mean, that was the argument to the judge, was it's a numbers game, 95% might be substantial performance, 26% is not. Boom, there hasn't been substantial performance. My reading of the transcript, and again, I was not counsel that argued against Ms. Atkins, and she may correct me if I'm wrong. My reading of the transcript was not this huge debate about whether the work was done properly or not. It was, this is a percentage of the work that's been done. That can't be substantial performance. Boom, they lose.
On the breach of contract where the summary judgment was denied, was it determined there was a factual issue as to who breached the contract first?
It just says the remaining defendant's motion for summary judgment on the remaining counts is denied. There's nothing in the order that articulates why those were denied, except that you would have to assume an issue of fact. Well, I'd love to assume he thinks they lose on theirs, but since he didn't rule on ours, if the judge had actually made a determination as to which count should prevail, then the judge should have done that. But since all three were denied, one of ours and two of theirs, it suggests to me that there's a disputed issue of fact inherent in his findings. I didn't prepare the order, so I don't know where the judge was going with that. I know in the exceptions, we tried to raise the issue, all these issues, and they were disregarded by Judge Whitehead when he adopted the order. I'm down to my 5 minutes, so I would like to sit down if that's possible.
May it please the court. Good morning. My name is April Atkins, and I represent the appellees Chris and Sandra Knowles, who are the landowners in this case, and they're seated here in the gallery. The summary judgment in this case should be affirmed in all respects. I'd like to
begin. Do you
begin.
think the trial judge misapplied the substantial performance doctrine?
I do not, Your Honor, and I'll tell you why. It's because the substantial performance doctrine has been applied to construction lien cases in Florida since the 1962 case of Pitts. And there's 7 cases decided in the last 45 years after Pitts applying the substantial performance doctrine in construction lien cases.
But as a defense?
What the cases say is that the contractor is not entitled to a lien where he fails to substantially perform the work.
Unless it's excused or waived.
That's not in the cases.
Well, are you saying, say a contractor and a owner, property owner agree it's going to be $1 million construction of a building, and the contractor does $400,000 of work, and the owner says, look, I've changed my mind, I want you off, goodbye, and there's no breach, if you would, by the builder. Are you saying because he only did 40% of the work that he can't file a lien?
I'll tell you, and I want to answer you, yes, that's what I'm saying. And the reason is, and it's perfectly consistent, although the policy argument raised in the reply brief in here was not argued below, the policy argument should not be accepted. That result is consistent with existing law, and it's consistent with the purpose of the construction lien law. The purpose of the construction lien law is to extend this extraordinary remedy of encumbering real property with a lien to secure the payment for the construction of improvements on that property. So if the work isn't substantially performed, the extraordinary remedy should not be available. Now, that doesn't mean that the contractor who doesn't substantially perform doesn't get paid, because he stands in the same position as most litigants with his contractual remedies.
There's only remedies, a breach of contract with no lien, no attorney's fees.
Well, it depends on whether or not he has attorney's fees in his contract, but no, he wouldn't be entitled to attorney's fees under the lien law because he wouldn't be entitled to encumber that real property. If he doesn't perform the work, then he shouldn't be entitled to the extraordinary remedy of encumbering that real property with the lien.
Even if he fails to complete the work because the owner kicks him off?
Even if he fails to substantially perform the work because the owner kicks him off. And that's fair because it's the real property that's at risk.
So if he does 60% of the work and the owner unjustifiably kicks him off, he's not entitled to a lien?
He's not entitled to a lien. He's entitled to his contractual remedies.
I don't think that's the law.
Well, I want to address a couple questions that the court posed to the appellant. But first, I would like to address that main concern of yours. In the Pitts case, it articulates a 3-part rule, a disjunctive rule, and the first part is that the contractor is not entitled to a lien where he fails to substantially perform the work.
But that isn't about a paragraph later, they use the language unless waived or excused by the owner?
Well, and I'm glad you brought that up because I would like to talk about that language. Those 2 sentences in Pitts are the only authority cited by appellant for their argument that there's a waiver or excuse exceptions to the application of the substantial performance doctrine in construction lien cases. So on the one hand, you've got Pitts and you've got 7 decisions decided in the last 45 years after Pitts that all apply to substantial performance doctrine in lien cases. And on the other hand, you've got two sentences in Pitts, which is a 1962 case, which is not out of this district, and it's not a Florida Supreme Court case. And they're dicta even in Pitts. Why? Because in Pitts, the contractor had failed to substantially perform, and so the court ruled that the contractor was not entitled to lien rights. In fact,
But the cases you're relying on, do any of them involve a situation where it was the owner was the one at fault? I mean, aren't all those cases the contractor was at fault and not completing the contract, as opposed and no wrongdoing by the owner?
all those cases where the substantial performance was not achieved,
Right.
the only two cases argued by either side here where substantial performance was not achieved are Pitts and Braverman.
Right. But none of those cases involve situations where the owner acted wrongfully in terminating the contract.
In Braverman, the facts, there's only the two cases. In Braverman, the court ruled that even though it involved a pool enclosure, and the contractor built the whole pool enclosure, but he hadn't gotten the permits. And so this became a big mess for the owner when they had to go through the
That wasn't the owner's fault, that was the builder's fault.
Right. And in Pitts, there was a dispute before the contractor, Pitts is actually very similar to this case. In Pitts, there was a dispute about whether the work was performed according to the plans prior to it being substantially performed. There was a dispute between the parties. The court never articulates in Pitts whose fault it is. But I think that's because the Pitts case, it never reached the third disjunctive part of that rule, which is the one you're interested in, about the fault. But it never got there because the contractor in Pitts had not substantially performed. See, our position is it's a three-part disjunctive rule. So you never get to the fault unless they've substantially performed. And the cases follow that. So if the contractor hasn't substantially performed, then you don't consider the fault, because that's the third prong.
Okay. The motion for summary judgment for breach of contract, was that based on, did you in your motion say that they had breached first?
Honestly, I would have to look at the motion for summary judgment. I'm sure that was the basis of our argument, because our performance was payment, which was due full on completion. But that motion was denied, and one of your questions earlier was as to the attorney's fees that had been awarded and what happened to those remaining counts. Those counts, the only basis for the subject matter jurisdiction in the circuit court was the lien claim. When the court ruled in our favor on the motion for summary judgment, it entered final judgment in this case, transferring the balance of the claims, both Mr. Knowles' $11,235 breach of contract claim and our client's counterclaims to county court.
What I'm trying to figure out is the motion for summary judgment for breach of contract was denied. The motion for summary judgment on the lien count was granted. Is the only difference the argument that they only did 26% of the work? And
The only difference in what?
As far as the basis why one motion was granted and one was denied?
Honestly, the other three motions, the hour-long hearing in front of Judge Glatt, the bulk of it was taken up with the fight on the lien case. The other three motions, basically, after he ruled as to the motion for summary judgment on the lien claim, we had used up 45 minutes of the time. He said that he felt like that breach actions usually involve disputed issues of fact that were appropriate for the jury, and that was pretty much the end of the hearing. And that the fraud, is the same kind of thing. But what we've got here is, like I was saying, we've got all this authority supporting the position that the contractor has to substantially perform.
How do you, your argument is falling flat with me, frankly, because of Section 713.05, which says that a contractor who complies with the provisions of this part, subject to the limitations thereof, have a lien on the real property improved for any money that is owed to him or her for labor, services, materials, or other items required by or furnished in accordance with the correct contract and unpaid. I mean, it seems to me that if the contractor does work and is unjustifiably thrown off the job, he's entitled to a lien
Well, I would submit to Your Honor
at any
that
point in the contract.
the substantial.
I don't
I'm
think
sorry.
substantial performance does that. Substantial performance is a doctrine which authorizes the collection on the part of the general contractor of a full contract price in the case that he fails to complete the contract, but the failure is insignificant. That's what significant performance is.
And I agree with Your Honor on that part. That is the definition of substantial performance. It is that performance which Your Honor is familiar with the definition of. But we're not arguing about the definition of substantial performance. What we're arguing is that these 8 cases decided in the last 45 years, because substantial performance is a judicially applied doctrine in this context, in the construction lien context. It comes out of Pitts, and the 8 other cases decided in the last 45 years all say that if you don't substantially perform your contract, then you're not entitled to a lien. And
Let me ask you this.
You've lost me on that one.
I don't think anyone's suggesting that your client, we don't know whether your client's unjustifiably threw him off the property. Is there a factual issue as to whether, as to who breached first?
no, there are no disputed issues of material fact in this case. As a preliminary matter, I would like to point out to the court that the only record evidence, as I'm sure the court is aware, is from the appellant. The only evidence in this record is the appellant's deposition testimony and the appellant's affidavit. So if there's any contradictions, it would stand to reason that the affidavit must contradict the deposition testimony. Either way, it doesn't matter because there's no disputed issues of fact here. It's undisputed that the appellant was only on the project for 11 days. In that 11 days, he only performed 26% of the work, and it's undisputed that part of the work that he performed was performed incorrectly.
Well, and you know, honestly, that might justify a refusal to award any mechanics lien for him because he didn't improve the property.
Right.
Okay. That's not the substantial performance test.
That's what I'm saying, Your Honor, about how it's an extraordinary remedy. They're still entitled to their contract rights, but if they don't improve the property, the purpose of the lien law is to provide the property as security for the improvements. If the improvements are not substantially performed, then there's no reason to put the property at risk.
If the improvements don't exist, it's not a matter of substantial performance.
One thing that puzzles me is if your clients, if there's no disputed fact that your clients had a right to throw them off because they breached the contract and they refused to comply, then I'm baffled why the judge denied the motion on the breach of contract. It seems to me that that's inconsistent, you know, regardless of which way is right. That the trial judge either should have granted a summary judgment on both counts in your favor or neither count.
Well, where we are here today, the judge denied the motion as to the breach of contract count. The undisputed facts include those facts that I've just given you, plus the fact that Mr. Langley didn't want to perform. He testified in the record that in the 11 days he was on the project, he had already asked the owners about being released from the contract early because he was having a personality conflict with another contractor on the project. And he testified that he proposed several repair solutions, all of which were unacceptable to my clients. And when they requested, and he refused to perform the solution that they requested, that was some of your questions. At record 438, he testified that it was ridiculous. And at record 445, he testified unequivocally that he refused to pull out the entire footer. So when he refused to do that, my clients hired somebody else to do it, and he testified at record 447 that he was, quote, happy to be released from the contract, end quote. And he also admitted in deposition that he was never terminated by my clients orally or in writing. So those are the undisputed facts of this case. And the question is, do you want to make law today concerning this waiver or excuse exception argument opposed by Mr. Langley? Now, The construction lien law has been on the books for 122 years. As I mentioned before, the substantial performance doctrine has been in existence for at least 45 of those years, and no case has ever held that the waiver or excuse create an exception to the application of the substantial performance doctrine in construction lien cases.
And why wouldn't it logically apply?
Because those are contract offenses. And the construction lien law is a special statutory creature.
And show me where in the lien law we find the words substantial performance doctrine.
It's not, it's a judicially created doctrine, Your Honor, but I can show you 8 cases decided in the last 45 years applying.
But tell me why waiver and estoppel would not apply to the substantial performance doctrine.
They wouldn't apply because they would apply their contract defenses. And the only 2 sentences that those concepts are lifted from, the only authority that appellant argues are those 2 sentences out of Pitts, which, as I mentioned before, are dicta in Pitts, and they're also not cited or followed by Pitts.
Regardless, why wouldn't they apply?
Because it's an extraordinary remedy. We're not talking about your
Substantial
average.
performance is not in the statute. It was judicially created. Why can't a court modify that judicially created doctrine?
Well, I mean, that's your choice here today, Your Honor. If you would like to...
I'm not saying we will. I'm just saying that I don't see the logical inconsistency.
Well, to me, it makes sense that the substantial performance doctrine applies because of the extraordinariness of the remedy of encumbering the real property. And I don't know why you would make exceptions allowing it.
So I'm building a motel on the beach.
Okay.
And I decide the contract calls for a pool deck. Okay? I get 80% through. I'm getting ready to start at the pool deck, and the owner says, you know what? You don't need to do the pool deck. It's okay. I waive my right to require you to do the pool deck. Then the contractor sues under the mechanics lien law, and your client then says, well, he didn't substantially perform. He didn't put the pool deck on.
Well,
Why wouldn't waiver apply there?
waiver wouldn't apply because, of course, you wouldn't lien for the pool deck work because you didn't perform it.
But your position is that if you don't substantially perform, you don't get a lien.
But it's substantially performing the contract. I think that a court, and substantial performance under Florida law is an objective standard. It's that definition that we're familiar with from contract law, about how it's the performance of a contract which will not full
Substantial
performance.
performance is contract law?
What the lien law does is, and this is why it gets confusing, Pitts and these 8 cases say if you don't substantially perform, then you don't have lien rights. But then where do we look for the definition of substantial performance?
But all those 8 cases deal with the situation where the contractor has done the wrongdoing.
No.
Yeah. You tell me one where the owner did the wrongdoing, and as a result of the owner's wrongdoing, the contractor lost lien rights. Show me any of those 8 cases.
Well, I can't, the thing is that 6 of those 8 cases they had substantially performed. So they never look at fault.
And the other 2.
And the other 2 are Pitts and Braverman.
And
Pitts, they say
Braverman is
there
clearly,
was a
and
dispute.
Braverman is clearly the contractor's
contractor's
error.
fault.
And Pitts uses the less excused or waived language. So neither of those 2 support your position.
I think that they do support my position. Because our position is, it's a 3-part rule. The contractor, and I'm quoting from Braverman and Pitts, the contractor is not entitled to a lien where, 1, he has not substantially performed his contract, or 2, he has failed to perform a material and considerable part of the work required under the contract, or 3, where he has willfully or intentionally departed from or failed to carry out the terms of the contract. And the cases I would submit to you that consider the intent or fault of the respective parties are decided under this 3rd prong. But because of the use of the word or, it's clear that these are 3 separate things. In those cases where they consider the fault, all those cases, the contractor has substantially performed the work. And that supports my position that these are three separate requirements, or three separate considerations.
But number 2 and 3 don't deal with substantial performance,
But number 1 does.
but not 2 and 3.
But not 2 and 3, but they're three separate things. In other words, of the 8 cases that have been argued by both sides below, in all of the cases where the contractor had not substantially performed, he was denied lien rights. And in the cases where the contractor had substantially performed, the court looks at, it wasn't that he automatically got lien rights, but he wasn't denied lien rights for not substantially performing. So in those cases, the court looked at other issues, and I'm out of time.
Thank you, counsel.
Thank you very much.
Ms. Moses, you got a little more than 5 minutes.
I suppose let me ask you, is there or is there not a material disputed fact as to whether your client told the owner, I am not going to pull the footers out?
I think there's a disputed issue of fact, and I take exception to the suggestion that there were no disputed issues of facts in this case. If you look at their answer, they've denied any factual allegation in this case. Anything we've asserted, they have denied. Correct, the Knowles did not file an affidavit that contradicted ours. But if you look at what we alleged in order to recover and what they have admitted or denied, there are clearly disputed issues of fact. We alleged we were wrongfully terminated. They denied that. So there's a disputed issue of fact about how this job ended.
All right, but did your client tell the owners, I am not going to pull the footer out, period?
I looked at the depot real quickly, and the way it reads, and it's not artful. In fact, at one point he says, I'm sorry, I just looked out the window, I lost my train of thought. The way it reads, it suggests that there were some discussions still going on about it. Yes, my client said, I thought it was a bad idea to pull it out and do it this way. Yes. But he says next he got a call that said, you're done with the job. But your questions to me go to a critical point, and it's about the substantial performance doctrine. And when we get to that third prong that says, or refuse to, or willfully or intentionally refuse to comply with the terms of the contract, we are not suing for the entire contract.
I understand. If your client had said, I refuse to pull the footers, period, and it was a material breach of the contract, should they have been entitled to summary judgment on the breach of contract count as well?
Should they have been entitled to summary? I don't think so.
I mean, if that was undisputed, that your client said, I'm not going to pull the footers, and if his refusal to redo the work was deemed a material breach, would they have been entitled to summary judgment, if you found those two elements?
If he absolutely refused to pull the footers. I do not agree, Your Honor, because there is still an issue as to what we did provide and whether that complied in part with the contract. This clearly should not have been something resolved at the summary judgment level, period. There are just too many disputed issues of fact.
Couldn't the trial judge grant a summary judgment as to the breach and just leave for determination later the amount of damage?
That might be a possibility. That might be a possibility, although I think there was a dispute as to the breach, as to whether it was unreasonable to ask us to do something that we were willing to pay for the correction ourselves. I mean, my client's position was, I am offering a solution that can fix this. I will pay for the engineer to certify it. I will make it work.
But does the owner have to accept it? I mean, can't he say, I insist that you do it according to the plans?
Yes, but there was a dispute as to what the actual plans were and whether you could deviate from the plans. That was another issue in this case with respect to the waiver and estoppel, is we were told to comply with the plans unless you needed to deviate. I mean, again, I'm not trying to create an issue of fact like the first case this morning. There truly were disputed issues of fact on every issue in this case. I'm sorry, that was probably inappropriate.
Yeah, it was.
But every opportunity, every issue that came up, there were two sides to the story. And again, the Knowles didn't file an affidavit, but my client did and said this was my interpretation of what I was asked to do or not asked to do or told to do when I entered into the contract, and I was allowed to deviate at certain points if it was necessary. It was just disputed everywhere. And I don't know how, in your example of being told not to put the pool deck on, how you can then not recover under the contract, how the Knowles can stick with the substantial performance argument in that context, I find it unbelievable. If your contractor is doing the job and is told not to do a certain portion of it, but can't recover because he hasn't substantially completed, I cannot imagine that was the legislature's intent in creating the lien statute. I absolutely cannot believe that. And I also believe that you cannot rely on Pitts for a theory and then completely disregard anything in the case that you disagree with. Pitts provides for an excuse or waiver. We've given plenty of examples of excuse or waiver. There were substantial issues of fact with respect to excuse or waiver, and this is simply a case that needs to be reversed because summary judgment was inappropriately entered.
Thank you. That completes our calendar for today. We'll be in recess.